Thank you for joining us, everyone. My name is Simone Ostrowski. I'm here with my colleague, Daniel Chodos. We're both lawyers here at Whitten and Lubline, and we practice exclusively in employment law. And we're here today to talk about employee illnesses in the workplace and some of the issues that we see most often from our clients. So, Daniel, I'll turn it over to you. What issue do you see most often related to employee illnesses?
One thing that I see constantly are employees who are having difficulties at work because of an illness of some kind, and the interplay between that and dealing with insurance companies. We have to work frequently with personal injury lawyers, particularly because that's just the reality of the situation. If you're having difficulties at work because of an illness, you may have to miss work, and if your employer offers coverage for disabilities, you may take on a disability case as well. And so that's something that we're always flagging and always addressing. And of course, the problem you run into sometimes is, what if the insurance company doesn't agree with you that you're sick and the insurance company denies your claim? Now, all of a sudden, you're in a position where you feel like you have to go back to work. More importantly, the company you work for might feel like you have to go back to work. But the lesson for a lot of employees is that is not always the case. And so I'm dealing with various stages in this process where I'm advising employees saying, look, you don't necessarily have to go back to work if you're considered disabled. It doesn't matter if the insurance company doesn't agree with you. Their definition of disability is different from the one in the Ontario Human Rights Code. And that's what matters most when it comes to accommodating mental illnesses at work.
That's a good point. I often deal with a lot of employee misconceptions as well when clients come in and ask for help with their workplace illness. For example, I find a lot of clients seem to think that if their doctor recommends certain accommodations at work, the employee can just take that note, give it to their employer, and the employer automatically is obliged to institute those accommodations, and they're somehow in breach of the law if they don't, when in fact the employer is the party that actually gets to decide which accommodations the employee gets, and it's the employee who has to provide medical restrictions and limitations from their doctor. But it's not actually the employee that gets to decide what accommodations they get in the workplace. So that's a big misconception that I see. What about you? Do you see any other misconceptions among your clients?
I mean, definitely that's something that I see so frequently is from both sides of the coin. On the company side, they're saying, well, wait a minute, we can't just give this employee what he or she wants. We have a right to decide how to run our own workplace. So you're absolutely right about that. It's a balance between employees being accommodated and employees getting their preference. The other thing I see sometimes is employees who maybe don't necessarily know what a disability is. If I get a cold, I don't think I'm disabled necessarily. If I have a condition where I'm constantly getting colds, that might amount to a disability. So
for sure. Yeah, definitely the primary concept regarding a disability is that it's something that is not temporary. So things like cold or even arguably a sprained ankle, those are temporary conditions. So we would not see those types of conditions falling under the legal definition of disability.
No, absolutely. I mean, I'm sure you see that sometimes there's these sort of middle grounds between what is and is not considered a disability. The Human Rights Tribunal has lately considered some cases that deal with that kind of concept. So, for example, if you sprain your ankle and have to miss several weeks of work, is that a disability? There was a case a couple of years ago involving someone who suffered a miscarriage, and there was a lot of discussion both in the legal community and in the media generally about whether or not that could constitute a disability under the Human Rights Code. And you see a lot of other examples of that where it's not necessarily clear on the surface of it, right?
There's definitely a lot of content related to employee illness that we could discuss, and I'm sure a lot of you have questions. If you want to speak to us or any other Whitten and Lubline lawyer, our information is at the bottom of the screen, or you can go on our website or call our telephone number for a consultation.
Thank you very much.